This year's Ella Conference is appreciative of all of our sponsors. Our presenting sponsor, Gallagher. Our gold sponsors, the Arkansas SHRM chapters of NOARC and CARA, Windstream, Cross Gunner Witherspoon and Gauchus, and Wright Lindsay Jennings. Our silver sponsors, SFLIC, Consolidated Admin Services, Friday Eldridge and Clark, and the West Central Arkansas SHRM chapter. Our bronze sponsors, First Staff and the Human Resources team. Now, let's hear a special welcome from Consolidated Admin Services.
Since 2009, Consolidated Admin Services has focused on our customer service and compliance for our clients.
Our team collectively serves over 1,000 clients, administering FSA, HSA, HRA, COBRA, FMLA, ACA, and ERISA compliance.
You can learn more about CAS and our team by visiting www.consolidatedadmin.com or calling our office at 501-941-5956.
Thank you. My name is Misty Borkowski. I'm an immigration attorney with Cross Gunter Witherspoon and Gauchus law firm in Little Rock, Arkansas. Our law firm focuses on employment, labor law, defense, and I'm one of two of the immigration attorneys at the firm. So today's presentation is called Immigration Law Bingo. We hope to provide some entertaining bingo cards that will be used as you go along through the presentation to keep you engaged and keep you learning about immigration law. So just generally speaking, when I talk to people about immigration law, I say that there are different bubbles, and that's important to know because everyone often will conflate and think that everyone is just going for naturalization, and that's not the case. There are definitely different levels. The non-immigrant visas are different types of visas that allow individuals from foreign countries to live here, work here, study here. They're all very specific and very unique to who the individual is and what they are trying or wanting to do in the U.S. and maybe even for whom they're here for. The other bubble is immigrant visas. These are when you think of someone who is coming to the U.S. or wants to stay in the U.S. lawfully and be a lawful permanent resident. Those are called immigrants, and those are often referred to as like green card holders. And then your next level, after you've become a lawful permanent resident, you can naturalize. You can obtain citizenship and be called a U.S. citizen. So typically, again, in these different categories, we're looking at, in the context of immigration law, you have a temporary visa that's here for a limited period of time. It's limited in scope, it's limited in what it can do and what you can do in the U.S. on that visa. And then you can have your permanent visa, which is the immigrant category where you're here permanently. You're allowed to live, work, travel in and out. And then there are some, of course, exceptions even to the permanent visa as limitations on how long you can be outside of the U.S. because you want to maintain your residency. So again, with immigration law, sometimes we call it alphabet soup. Sometimes it sounds like we're singing E-I-E-I-O because there's so many different letters and categories that are part of the non-immigration visa categories. These are not just willy-nilly named. They're actually the sections, the letters, and the numbers are often associated with the section of the Naturalization Act that put them into place. So of all these different visa categories, again, these are temporary and they have limited reasons for their entry. And so you may have someone who enters in one category and then they may be able to move over into another category, another visa category. And some of these are the ones that you as HR departments are going to see most frequently. And that's really what today's discussion is going to talk about and focus on is the things and the categories that you're most likely to see and what they are available for and how you can maneuver within those or to the next, kind of the next level or the next step. So often you will have someone who enters the U.S. as a student. And those individuals will come in as student visas. Or you may even have some that have entered the U.S. and because this is not necessarily a quote-unquote non-immigrant category, I wanted to also mention DACA, because you may well, as an employer, have someone who is not necessarily have a visa, but they have, by virtue of DACA, which is Deferred Action for Childhood Arrivals, they may have employment authorization that's been issued by the government. So there have been a lot of changes in DACA and in other categories that I'm going to try to mention as we go through this. But there has been attempts to end DACA, to restrict DACA, to really limit the scope of being able to renew or allow new individuals to apply. And so there's obviously, over the last year, there's been a lot of litigation in trying to rein in DACA. And so right now, we are in a position where new DACA applicants, so brand new individuals or individuals who are just now eligible, they're not necessarily able to apply, but we are allowing individuals to extend their DACA status or their DACA category. Again, as employers, one of the things that you will likely see is someone who has been in the U.S. and is still in the U.S. as a student visa. So those are often F1 students. You may have someone who actually has an M1. We don't see those very often, but those are also student visas just going through a vocational program. And we also will often see someone who may be on a J1 visa, and that's an exchange visitor. We actually see a lot of physicians. So if you are in a hospital or physicians group setting, you may well see someone who has been in the U.S. studying a residency or fellowship program, and they may be on a J1 visa. Those are very important visas to be aware of the possibility that there is a 2-year residency requirement. The reason for that is the government wants to allow individuals to come into the U.S. and then their home country wants to encourage them and make sure they return home to share their knowledge. And so the 2-year residency is requiring them to return to their home country for a period of 2 years. There are actually waivers for that. We do a lot of J1 visa waivers for physicians group and hospitals that will allow the physician to actually work in it's a medically underserved area. And by doing that for 3 years, they are able to get the J1 visa waiver. So you may not see that unless you're in a physician's group or hospital setting, but I did want to mention that. So the reason we often will have your initial contact with someone will be while they are on a student visa is because after they complete their their studies, so a bachelor's degree, they may be in a master's degree, even a PhD program. Once they finish that program, then they are eligible to apply for OPT. And that OPT allows them to get a year of experience with a U.S. employer. And this is often your first opportunity for the foreign nationals to work for your company and build that relationship, and also for you to have a chance to view the foreign national and say, yes, this is someone that is an asset to our company, they're an asset to our group, and we want to keep them here and we want to see them grow and stay in the U.S. working for us. So student visas and the OPT gives them 1 year after if they're in a STEM subject, science, technology, engineering, or mathematics, they will be able to extend for even a long period of time on the OPT. And again, that is something that is a real benefit to the foreign national and to the employer. So this is often sometimes what you're going to be seeing if you have a student visa, or someone who's on a student visa and they have the employment authorization document. You know, I can, if an employer gets this and they don't really know what they're looking at, I can take a look at this And, just by looking at what the category is, I can tell you if they're DACA, I can tell you if they have an adjustment of status pending, or if they're on OPT. There's a lot of information that's on here, but some of the most important information that you're going to be looking at is that expiration date, because this is going to be a document that's going to be the authorization for employment that you'll use in the I-9. And we'll talk more about I-9s a little bit toward the end, but that is going to tell you how long they have authorization for employment. And of course, that's going to give you a kind of a deadline for what is our next step. Do we need to know if this individual is going to apply for a STEM OPT and be able to stay here longer on the employment authorization document, or is this going to expire and we need to immediately start talking about what are our next steps? So sometimes, or most often, the next step is going to be that you are interested as an employer in having the foreign national get onto the H-1B visa. There are things to just be aware of. There are some employers who are going to be cap exempt, meaning they can file at any point. And so, when I talk to universities and hospitals, they may have a relationship with an institution of higher education. Public schools will often have an affiliation with a local university or college because they want their student teachers to come in. So there are certain things that will allow an employer to file as a cap exempt employer. And that's very critical, because although, the H-1B process there are certain time limits, if the employer is cap exempt, they do not have to worry about the time limitations. They do not have to worry about, we've got to get, this individual has to be selected in next year's lottery or they will run out of time. So always think, or always ask the immigration attorney about whether or not your company may be cap exempt, your entity may be cap exempt, because that's certainly a discussion that's worth having. However, if you are an employer and you've gone through the analysis of whether or not you're cap exempt and you're not, then you're going to have certain days and certain times that you're going to need to be aware of. The foreign national will often be on the student visa, and of course if their curriculum ends and they get their bachelor's degree or their whatever degree they're working on, if they get that at the end of the summer term, that's going to often put them starting their 1 year on EAD from, say, June or July to the following June or July. So that's going to be your typical time frame, which means in the spring of that next year is when you're going to need to be discussing about H-1B sponsorship, because there is now a registration period that starts in March. The system has actually really improved over the last couple of years. Previously, we would have to submit the entire petition packet, and we would send in this huge stack of papers, and the government would get bundles and bundles of these, and they would have to sort through them and do the lottery that way. Well, now we have a registration system that conducts the lottery, and so it's much more affordable. It's like a $10 registration fee that is submitted into the system, and then in April is when the government will do the lottery selection. There are a limited number of visas, so that's kind of the key, is that throughout the entire United States, there are 66,000 H-1B visas for bachelor's degree, and then there is an additional 20,000 that are designated for the master's degree. And they have the system for the lottery selection actually gives everyone who is registered as a master's degree eligible, it gives them 2 bites at the apple, because it does the selection for the master's degree and then it puts them also with the bachelor's degree, and we'll do another selection. So the selection happens, and once you are selected, then there is a period of time that you have for submission. And that's when you gather all of your paperwork and put your entire H-1B petition packet together for submission to USCIS, who will then administratively process the case. The thing to know is that you will have a period of time, your actual approval, let's say you get the approval will not be for a start date before October 1 of that year. So often, like we talked about, you will have an EAD for the student that EAD may end in June or July, but you now have an approval that's in October. So this period of time there's a provision that allows for cap gap. That's what it's called, but it basically allows that student to continue working with you because they have a petition that is either pending or has been approved. And it bridges that period of time to allow the student to not have to sit down or sit out of work for that period, for those couple of months. So a couple of things that employers are going to always think about when they're deciding whether or not to file an H-1B for one of their foreign national employees is going to be the legal expenses, the filing fees. So for example, the filing fee for the petition is around $460, but then you have an ACWIA fee. If you are a company with under 25 employees, that's $750, but if you have more than 25 employees, you're paying $1,500. And then there's a $500 fraud prevention and detection fee. And then on top of that, if you want a response within 15 days, you would have to pay the premium processing fee, and that would be another $2,500. So there are a lot of expenses involved in the H-1B. You do get the H-1B. They're issued in 3-year increments, so you will be able to have 3 years with the foreign national and then extend the H-1B for another 3-year period. There is a 6-year total limitation that someone can be on the H-1B. However, what we typically see, and I've got some slides on this, what we typically see is around year 4, employers are starting to think, I want to go to the next step. I want to file for permanent residency. I want to sponsor this foreign national to become a lawful permanent resident. And there are ways that once you get to a certain point in the permanent residency process that the foreign national is able to extend beyond that 6-year limitation. So there have been, as I mentioned earlier, there have been a lot of changes, especially with H-1B. Under the Trump administration, there were a couple of things that were just completely have thrown and would have continued to throw the H-1B process and the potential for the H-1B into kind of pretty much a tailspin, because one of the things that occurred was redefining specialty occupation. We have always said, you look at H-1B, it's a specialty occupation, and what that, generally speaking, means is that you have a job that requires someone to have a bachelor's degree, and the foreign national has a bachelor's degree in that area. So you couldn't file an H-1B for someone who was going to be a bank teller. That doesn't require a college degree. Same way you couldn't file for someone to be a mechanical engineer and they've got a finance degree. They have to be together. Well, what was happening under these changes was that USCIS was really restricting how we were defining specialty occupation, and they were doing it in a way to very much limit who was going to be eligible. So, that mechanical engineer, well, your job with your company, it may be titled mechanical engineer, it may be engineer, but you could have a mechanical engineer, industrial engineer, you could have a variety of things. And what USCIS was trying to do is say, no, we are only going to allow one specific degree. That job has to have a specific degree, and that was too confining, and it went against how specialty occupation has been defined in the court system. So that was something that has been, as part of this lawsuit that was filed, has been vacated and remanded to Department of Labor. And then now, of course, is definitely on complete hold and not going to be moved forward. The other part that was going to be very, very devastating to most employers was changing the way the wage values were going to be calculated. So the goal in the changes that were trying to be made was to, instead of allowing someone who had come out of college and was in an entry level, say that mechanical engineer was in an entry level position, well, now the wage requirements that were available were going to basically be for, you know, someone with a much higher experience, you know, a lot more experience than an entry level. So employer was not going to be able to look at this new mechanical engineer and be willing to pay them a wage that they would say, well, I pay somebody who's been with the company 4 or 5 years that wage because they've got experience. So it was really changing the computation for the prevailing wage levels was going to be really hurtful to not only employers but also to foreign nationals, because again, they most often get into the H-1B visa because they have just come out of college and they've just gotten a bachelor's degree and they're trying to get that experience. So as I mentioned, the wage level rule has been postponed. It's under review. We're hoping that there are even more changes to that because it was actually Department of Labor rules that were implemented. It's not just, you know, it's not just by a signature that can go away. It actually, there has to be more effort to get rid of it or restrict it or redefine it, but at least we are now pushed off until 2023. Again, because there were a lot of denials that were, we would say, erroneously issued. The government would probably, I guess they are now agreeing, because under the Biden administration there had been a lot of H-1Bs that were previously denied, and the government is reopening those cases and notifying the employer that they are being adjudicated now. One thing, if someone is on H-1B, then their spouse can be on an H-4 visa. Historically, H-4 visa, you know, for a spouse family member, they were only allowed to live in the U.S. They couldn't work. So now there was a change several years ago that allowed them, if they met certain qualifications, that they could apply for an employment authorization document. They could also work. And under the Trump administration, they were trying to pull that back. They were trying to claw that back. And so we have been able, with the Biden administration has pledged to keep the H-4 EADs in effect. One thing that was very challenging, especially in the last 2 to 3 years, was there was a public charge rule that went into effect. And what that did was, it was kind of, we called it a wealth test. It was requiring, you know, normally for the H-1Bs, we have to show that the employer is a legitimate employer and this is a legitimate job, and the pay, the prevailing wage that is required to be paid is going to be and can be paid by the foreign national. This took it another step, and it actually looked at the foreign national and it wanted to know, you know, what are your bank accounts? What are your savings accounts? Do you have health insurance? How many individuals are in your family? What's your credit score? So the public charge rule that went into effect, it was a big problem for people who were adjusting status to become a lawful permanent resident, but it wasn't limited to lawful permanent residency applications. It also went to the foreign nationals who were applying for a visa like an H-1B because they were filling out the I-129 form. So that has been abolished. So as I mentioned, you have your individuals who are here as a non-immigrant, and then the next step is often the employer says, you know, we are at some point going to run up against the 6-year visa, the 6-year limitation on the H-1B visa. We need to start thinking about sponsoring this individual to become a lawful permanent resident. A couple of key things that I always tell employers when they're thinking about this is you have to look at this and make some assessments. First of all, you have to know that when a foreign national receives the lawful permanent residency, when they receive the green card, there is no longer a commitment. They no longer have an obligation to the employer. They may have loyalty that keeps them there, but it's just important that the employer know that it's entirely also possible that they no longer continue working for the employer. You wouldn't want to be blindsided by that at the end of the process and then come to me and say, why is this individual left and I have not already told you that? The other thing that is important to think about if you're considering the immigrant visa process for a foreign national is, generally speaking, if I were to recruit for this position, would I have applicants for individuals who are qualified? It's called U.S. workers, but that's a very loose definition. But really what you want to know is, you know, have I been searching for this position and I have not gotten any qualified candidates? Or if I put out an advertisement for this position, am I going to get 40 qualified candidates? And of those 40 qualified candidates, you know, I'm going to find out that 10 of them are quote unquote U.S. workers, which basically means they're going to be someone who does not require sponsorship for immigration purposes. So it really, you know, if you as an employer are analyzing whether or not you can go down this road, you're going to be thinking along those lines, because that's going to have to give you some assurance, not a guarantee, but you're going to have to at least know if we are doing the recruitment steps, in all likelihood, we are not going to otherwise fill this position. And the reason for that is because you're expending a lot of time and money and resources to go through the steps. And so if you're not going to be able to go all the way from beginning to end, then you may want to reconsider and reevaluate what your options are. Some other things to consider, and will be factors, it's actually not necessarily something that would sway you one way or the other, is what category. So, and we'll show this in a second, whether or not they're an EB2, they have a master's degree, or they're an EB3, they have a bachelor's degree, and then what country they are from, because that will be a factor of how long it takes between step 4, what I call step 4 and step 5, to actually becoming a lawful permanent resident. And then of course, you always want to be sure that while you are going through this immigrant visa process, your foreign national, you and your foreign national employee have to always maintain status and make sure that everyone is in compliance with the visa requirements. So just have a couple of graphs just to also put this in a little bit of perspective about the difference, because what we're talking about is employment-based sponsorship, but there's a whole other category of going through the immigrant visa process that is through a family member. And so you can see from the graph that actually most immigrants are going to become lawful permanent residents based on their family ties. And then you have a smaller percentage that are coming through the process through an employer. Also, just to put this in perspective, you know, typically we have a process that is very much stable and set in motion, and we really have never seen quite the dramatic dip as we did because of the pandemic, about the number of people who have been successful in going through the process to become a lawful permanent resident, and how much of an effect the COVID pandemic has had on this. You know, we've had field offices who have been closed. We have had, you know, government employees who normally would process this have been working remotely. Also, foreign nationals can become a lawful permanent resident, not just by filing within the U.S., but they've been able to file in consular process in a U.S. consulate abroad in another country. And that process has slowed to a crawl again because they've just been unable to get in and have face-to-face interviews the way they normally would. So we can definitely see what a decrease, what an effect this has had on the number of lawful permanent residents being approved and processed. So if an employer does want to go through, and I'm going to go a little bit quicker on this section about the employment-based sponsorship, is looking at the job description is going to be the first step, and that's super important because you want to have a job description that is definitely accurate. You're going to have to set out the minimum education requirements, minimum experience requirements, and it's very tempting to want to tailor those requirements to match your foreign national because that's the person that you want to qualify for this position. And you are always in a balancing act because you can't require something if you can't demonstrate that it's a business necessity. You couldn't have 2 mechanical engineers and require in the perm process something different because this is the foreign national and he or she has that skill or that knowledge or that training, that certification. You can't require something for that individual that you didn't require for other individuals in the same position, whether it's current employees in that same position or previous employees in that same position. So you have to be very careful about what you are requiring because if you were to be audited throughout this process, there are different times when you could be audited. And so if the Department of Labor were to audit you on your experience requirement, then you're going to have to demonstrate. You have to have documentation to demonstrate that this is a legit, what I'm requiring is not to tailor it to this individual, but it is actually a business necessity, and I can explain and demonstrate that either other employees have had that same or something about what your company is doing has changed to require the additional requirements. And then you have to go through the recruitment process. And this is what I was pointing to earlier about going through the steps and knowing whether or not are you going to get 5 candidates or are you going to get 50? Because this is the part where you're telling the world with limitations, of course, but you are broadcasting that I have a position, and if someone applies for it and they're a qualified U.S. worker, then the process stops and you're not able to go to the next step. If you do not have someone who is a qualified U.S. worker, then you are able to go to the next step of filing the perm application. And it's an online application. It goes to the Department of Labor. This is where you just have to match everything up. So you've got to demonstrate the job, you've got to demonstrate that you've met all the recruitment requirements, and then you have to put in information about your foreign national who has met and can demonstrate that they meet the education and experience requirements. And then you're also saying, I'm going to, I have been told by the Department of Labor what the wage must be, and that's the wage I'm going to pay this foreign national employee when they are approved for a lawful permanent residency. The step 4 is actually filing the petition. So once the perm goes to the Department of Labor, then it comes back certified. And that certified perm is critical. It's a critical step. It's a very important step because that allows you to then file the I-140, which is the actual immigrant visa petition that the employer, again, is saying, I am the employer, I have the ability to pay the wages that I'm willing to pay. The foreign national meets all of the qualifications, all of the requirements, and I am now telling USCIS that I would like to have the I-140 approved. And then the last step, which is the very important step also, is either the adjustment of status or consular processing of the foreign national. And this is a little, even though you get to this step based on the employment petition, this step is all about the foreign national, because it's all about this individual's work history, history in visa status in the U.S., travels abroad, family members. Do they have other family members who are also going to get this benefit? And also, very important, is there anything that this foreign national has done that would render them inadmissible? And so those are very important steps. Just to, generally speaking, what we were talking about as far as the categories, we call them EB1, which is extraordinary high level of individual. So you're in all likelihood not necessarily going to see someone who's trying to qualify for an EB1. EB2 is, again, it's going to be someone with a master's degree or a bachelor's degree and five years of experience, or you can have an EB3, which is a skilled worker or someone that's professional, a bachelor's degree, and then even other workers, so completely unskilled workers. I have this, this is the visa bulletin, and this is, it's about as clean as we have ever seen it. The reason being, all of the C's means that I can file step 4 and step 5 together at the same time. So you don't always have that ability. And you can see in the column designated for China, mainland China, and India, you have date, month, and years. And what that is, it's a reference to the priority date. So I'll just give you an example. If you're looking for India and someone EB2 category, so that means that someone with a master's degree or bachelor's plus 5 years, their priority date is 2011 for currently ability to adjust status. And that means that that individual has had an approved I-140. Not necessarily, the priority date is actually set by the PERM, but let's just say they started that process in 2011 and they are just now able to adjust status. So that's something that we always have to cover with employers and employees when they have someone who may be from one of the countries that gets a lot of backlog. So we haven't even covered, there are a lot of different things that foreign nationals, maybe, you know, you may have somebody that has an asylum or a refugee status or a TPS. So we're not covering all of that. I'm just kind of mentioning that just to say that there could be other things that you end up crossing with. The next section that I wanted to go into is the I-9. And again, I'm going to cover very briefly I-9s and even more briefly the E-Verify. I will say there's a lot of information in the slide for E-Verify. So please feel free to look over that, and hopefully it's a good resource for you. What we always tell employers about I-9 compliance is you're walking a fine line, because on one hand you have to make sure that you are, by virtue of completing the I-9, completing it in order to make sure that the individual you are hiring is someone who has work authorization. At the same time, you have to do it in a way and comply with the I-9 requirements in a way that does not cause somebody to feel that there is a basis that you have discriminated against them based on their foreign origin. So it's very careful on how you approach the I-9 with an employee. It does not matter if you can't pronounce their name because it sounds very foreign, or if their name is Bob Smith. You need to treat those individuals equally and in the same way. So to Bob Smith, you don't say, bring me your driver's license and social security card, but this individual, you say, I need to see a visa. That would not be an appropriate way to handle the situation. What we always advise employers is there's a document with the I-9 that has the column A and then the column B and C, and that our recommendation is that you're going to give that sheet of paper to the individual and let them choose what they want to submit to demonstrate that they have employment authorization. Complying with I-9, it's critical that you pay attention to the timing, that you're aware that you need to get the employment authorization done quickly. Also, you don't want to do it too soon. You don't want to do it in the process when you are still interviewing. You can't. What happens in that situation if you're completing the I-9 before you've actually offered and the individual has accepted the position, you run the risk of being accused of screening employees or potential employees, and it unnecessarily opens you up. I will say if you've ever had a question about the I-9, almost every question that you may come up with is definitely going to be in that handbook. There's a handbook available. It's very, very useful. They have a lot of questions and answers. They have a lot of scenarios that they provide. So I would always recommend looking at the handbook on the government website. You can Google it if you don't remember this or have access to it. In fact, I probably need to check the site, but you can Google employer handbook I-9s and you will come up with it on USCIS. So again, your timing, I have this completely spelled out for you about the timing of when to complete this, and make sure, it's what I always say is, like, usually when someone starts some work, they have a whole stack of papers that they're filling out. And the I-9 is just one of many things that employers and the individuals, the employer is going to look through and fill out. The critical thing, I think, is that you should not always assume that the I-9 has been the section that the employee fills out. Don't always assume that it's been filled out correctly. While they are there, while they are providing you with documentation, you should look over their responses and see, does this all look like it's been filled out correctly? And then that will give you the opportunity right then, right there, not later while you're doing an audit. That'll give you the opportunity to have a conversation with them and ask them to, if anything is left blank that shouldn't be blank, that they go ahead and have that opportunity to fill it out then. We do recommend that you do an internal audit. If what we've often done for clients or recommended that they do is if they have a large labor group, if they're, let's say, 250 people, take 10%. Just randomly pull 10% of your I-9s and do an audit. What happens sometimes with employers is there may have been changes within the HR department or changes within the office of who handles the I-9s. And so when you have those changes, you're getting different levels of training, different levels of experience, different levels of understanding about what is required for the I-9. And so if you do that audit from time to time, that will help you say, oh, we've done this audit and everything looks very good, like we are solid on our I-9s. If you do the audit and you are finding error after error throughout every single one of them, then you may want to consider going ahead and doing an entire audit, and just that will give you some comfort that you're catching it now, and you're correcting it now. You want to make sure that you do an I-9 for everyone, even an owner. Let's say if it's an owner that also works for the company and it's not just someone who is just on the books, but that you want to have an I-9 even for an owner of a company. You definitely want, it doesn't matter who it is, how long you've known them, you want to have the I-9 in the file. As far as documentation, and I know I didn't add this, but because of COVID, there has been some relaxing. I used to advise employers that you had to touch it. Somebody had to feel and touch the documents, and that is always a good practice. But there may be some updated changes that you need to be aware of if COVID is a factor in you being able to actually look at the documentation. You're not required to be an expert. This is the list A, B, and C. You are not required, if somebody gives you a document, you know, if they say that you have to use common sense, I guess is the point I'm about to make, but if they have a card that would have been printed when they were 12 years old and they have a beard, that may not be a valid card. So it does, you know, you can use common sense in deciding that this does not look like a legitimate card. But I can tell you, I have seen, especially if it's a lawful permanent residency card, I've seen so many variations, and they're legitimate. Like, the government has changed that card a lot over the years. They're always trying to enhance and improve the security features on the card. And so for that reason, you're not necessarily going to be able to find a way to verify that some format is or is not authentic. So you're not required to be an expert. You're just required to make a good faith effort to look at the documents and verify as best you can that they appear to be legitimate. We often advise employers and recommend that employers will keep copies of the cards. Again, if it's the same thing. If you do it for one, you must do it for all. So on your I-9s, you know, at some point, if you're going to start keeping copies, if you haven't in the future, that's fine. You don't have to go back and obtain copies, but it really helps later if you're doing an audit to have those copies so that you can see why something was listed the way it was. We used to recommend that you keep them apart from the personnel files. In fact, this slide still shows that, but the government has changed their position on that, and it can be kept in the personnel files. I think one reason for keeping them separately, and of course this depends on the size of your workforce, but if you were audited by ICE and they wanted you to provide copies of all the 9s and supporting document, if you have them all together, it's easier for you to provide that. I also have recommended in the past that, especially because of documentation that may expire, that you keep lists or batches of employees based on active employees who require reauthorization at some point, and then former employees, because there is a retention requirement. And so if you have them by dates, then you can tell when somebody needs to, you can dispose of their form if they're no longer employed, and then also for requiring verification. I will make this point. Just because a document expires does not necessarily require you to go back and re-verify. So if you have a document that is going to expire, you may want to go to that handbook and look at the list of documents that do not require re-verification. I'll give you an example. Someone who has a lawful permanent residency based on marriage to a U.S. citizen, and they filed before they were married for 2 years, they will get a conditional lawful permanent residency. And so it's issued for a 2-year period, and then they have to apply to remove that conditional status. So even though that residency card actually will expire in 2 years, it's not one of the documents that's listed that requires re-verification. So it's always worth going and looking at whether or not you actually do need to get a re-verification of an employment authorization. I'm going to wrap up pretty quickly. This is just a cheat sheet of how long to keep and retain I-9s. Be familiar with when you can dispose of them. And then, of course, if you need help with an audit, you can involve counsel. If you are audited, you can involve counsel, definitely. And then, of course, there are penalties and reasons for always being in compliance. I'm not going to go past this slide, I would encourage you to look at the remainder of the slides so that you can see what are some of the penalties, what to avoid, and how to have a best practice for your I-9s. And then of course there is information for E-Verify. If you have any questions or need any information from me, feel free to reach me. My contact information is in the PowerPoint presentation. Again, my name is Misty Borkowski, Cross Gunter, Witherspoon and Gouches, and I appreciate the opportunity. Thank you.